welcome to Group Tour Professionals webinar on the kind of legal implications and liability around COVID-19, very different world we find ourselves in. We've got a huge variety of operators from all over the world joining us at the moment, which is great. So I'd just like to introduce the panel that we've got today. First of all, Kennedy's Law, who are kind of a legal behemoth company, very experienced lawyer, Claire Mulligan, is delighted that she's going to be presenting to us very shortly, accompanied by her associate, Ged Flynn. So welcome to the both of you. Kennedy's have kind of got, I think, about 60 offices around the world, or something like that, 6 in the US and 12 in Europe, and just a wealth of experience around the world. Claire is the partner and heads up the travel team, experienced in some quite frankly horrible issues in her career, and I've been lucky enough to work with Claire and present with Claire a number of times in the last 10 years. And representing the US, we've got Jeff from Mint Law. Thank you very much, Jeff, for joining us. Really appreciate it. Jeff's going to be talking a little bit after Claire and giving the US perspective on the liability issues. Now, it's fair to say that, as most of you operators will be aware, the law changes in different countries, and then in the US it changes in the States as well. So there are going to be hopefully a number of questions, and I've already had quite a few emailed to me. We may get to them all, we might not. Some of them might be a little bit too specific, but our commitment to you is that with the help of Kennedy's and I'm sure Jeff, we will answer those questions for you and get them back to you within the next 72 hours, posting on our Facebook group. So that would be that'd be great if you could carry on the questions coming in. Just before we hand over to Claire, just very briefly, bit of a shameless plug from me. I'm sure you're all aware if you're a member of our Facebook group, but on the 11th of November to the 13th, we have our free Tour Exchange Education and Entrepreneurship Conference taking place. Absolutely free, as is membership to the association. So if you haven't signed up for that, please do so. You'll find the link on our Facebook group, and I can share it in the email post this webinar as well. Loads of great speakers. Hopefully Claire, Jed and Jeff will be rejoining us for that as well as a whole bunch of other experts and professionals from different aspects of our industry. So we're absolutely delighted to be able to include that this year in our inaugural year for free. So thank you for those who've already signed up, and if you haven't, please get signing up. So enough of my wittering on. I will hand over to Claire to witter on in a much more focused and intelligent way than me. Thank you, Claire.
Thank you. So we're going to present this jointly, myself and Jed. So hopefully I can just share my screen for you all. So what we're going to try and do is just talk you through the legal issues coming from COVID that is really impacting the European tour operators that we've been working with over the last 6 months. So the main issues, is, as you're all sadly aware, is huge cancellations across the board of holidays. And what does that mean to you as the operator if it's your holidays being cancelled? The hotel being blamed potentially as a source of infection for those who do potentially contract COVID in resort. For those in the UK, we deal with the FCO, which is now called the FC and DO advice, which tells us where we can travel to and where they advise we do not to travel to. Then there's also potentially visa issues and quarantine issues upon arrival. We also, or those of us all in Europe, have the Package Travel Directive 2018, which provides requirements upon tour operators to give cash refunds, which at this time is clearly pretty crippling. And then there's been quite a lot of advice being given to members in the industry in the UK by ABTA, so we'll just touch on that. I'm not going to spend a lot of time talking about the package travel regulations because they might not all apply to you. But basically, COVID is very relevant as to cancellations in connection with the Package Travel Regulations 2018, as they mean that if you have an essential term of your contract, you know, usually going on holiday and skiing is potentially seen to be a essential term. If you can no longer offer the ski holiday because the resort is closed down, then you're not going to be able to provide the holiday. So there's going to be a need to reimburse the customer. The customer can decide themselves if they wish to terminate. So what we're seeing more and more is customers coming up to us proactively and saying, well, we don't want to go on holiday. We're worried about COVID. We're worried about catching COVID in the destination, or we're worried about quarantine issues. So there's a lot of debate as to whether they can or can't cancel their holidays in those scenarios. If you as a tour operator can't provide the holiday that's booked, then you can, of course, terminate the contract, and for reasons of force majeure, which is that it's unavoidable or extraordinary circumstances in the destination. But the problem is that there is compensation payable, and the package travel regulations dictate that you are, if a customer wishes, they can have a cash refund for the total holiday cost in the above circumstances, but that has to be paid within 14 days. Which is the problem that most of the tour operators that I'm working with just do not have the money to make the payment within 14 days because they haven't got the money back from the airline, or they maybe haven't got the deposits they paid to accommodation providers. And therefore, it's become a question of customer service skills in trying to keep customers happy and then giving them a refund, but when you get your money back. And for that, communication is key. And we very much would suggest that you have direct communication with your customers, be honest with them, and explain if you are going to be in difficulties to make the cash refund immediately, give them an expectation as to when it will be received. However, you might not be selling packages, and what we're finding more and more is that a lot of people are either just selling accommodation, or they're selling maybe just flights, or they've arranged their sales in such a way that they're actually selling a linked travel arrangement. Therefore, they don't sell a package and they don't have this cash refund obligation. And even if people were selling packages, what we're now finding is more and more people are coming to us and saying, right, we don't want to sell packages anymore. We want to unpackage our holidays, and we want to sell linked travel arrangements or single component accommodation only bookings. So there's lots of movement in the tour operator arena here in the UK at the moment. Your terms and conditions as to what you promise to do are absolutely key. The number of terms and conditions that we've looked at where people are quoting the old 1992 regulations perhaps shows how long ago people last looked at the terms and conditions. But you can protect yourself around COVID in your terms and conditions by having proper force majeure clauses, or perhaps selling as an agent. And I think that's really maybe an area you need to go back and do some checking, maybe just do a review and see if there are ways that you can improve the way that you're contracting with your customers. What we're also doing is we're working with a number of tour operators. So where there has been a cancellation of the holiday due to COVID, we're helping them to try and get reimbursement from travel insurers for their customers. And that's all around providing the travel insurers with a cancellation invoice. Despite the fact that England and the UK or part of the UK are Brexiting, so leaving the European Union, we have, however, agreed that we will keep the one piece of legislation which governs the package travel regulations, the package travel directive. That will remain, it's not going anywhere. So our obligations under the package travel regulations for those who sell package will continue. What's been interesting is whilst England is very much following the need to follow the package travel regulations around the 14-day cash refund, France, Spain, Italy, Germany, Denmark, Netherlands, Belgium, the current list of people who have decided that they are tearing up those parts of the package travel regulations and actually extending the refund payment window, or actually saying that credit notes should be provided. So France, for example, now has a credit note system where accommodation cannot be provided in accordance with the package travel directive. However, in the UK, we are committed to the good old trustee regulations, so we do still have to give a refund. However, it's interesting that ABTA have agreed under their code of conduct that they will allow tour operators up to 4 months period to provide refunds. It hasn't been made law, but that's just after recognising the difficulties that the European tour operators are having. The government have confirmed that any credit refund notes will have government protection in the same way that you have CAA protection for flights under ATOL. So if an airline or a tour operator goes bankrupt, having given a refund credit note, the government will back that credit note and make it cash. And what there was lobbying for was for a government consumer hardship fund to help fund payments to consumers. I'm afraid our government has rejected that scenario. And what we are seeing, though, is strong enforcement action by the CAA and the government against those airlines in Europe who are flouting the law by withholding the refunds following cancellation of flights. But what we're now starting to see is that airlines, rather than cancelling flights due to COVID and the fact they've got no passengers, will now fly the flights, because if you fly the flight, even though there's no passengers on board, the passengers who don't turn up to go on the flight because of their own internal lockdown issues are only entitled to a refund voucher. They're not entitled to a cash refund. So there's some interesting things going on with the airlines. So what advice are we giving to customers? Suggesting to customers that, so 1 second. Do excuse my dogs. So what we are suggesting.
I'm so glad that happens, because that's going to give me so much ammunition for years to come. So I'm so grateful for that.
It's usually children, but today it's dogs. So our advice to clients is, if they can't make a cash refund, is to talk to the customers. Understand or explain to customers that you haven't got the monies back from your suppliers, and try and get them on side to accepting the refund, but at a later date. Working with customers to potentially give them travel insurance as options, that they maybe can claim the money back for the holiday through travel insurance, and helping them with cancellation invoices. A lot of people still want to go on holiday, and I'm one of those people. So offering a postponement of the holiday, or a 2-year time limit in which to defer the holiday to, is what a lot of people are doing, and sort of moving the holiday down the road. But we're also seeing that the insurance industry has confirmed that travel insurance companies should be paying out for FCO cancellations. So where we cannot fly due to FCO advice against all but essential travel, the travel industry and the insurance industry have said that they will pay out to customers in those scenarios. And like we're seeing lots of credit notes, and then we're also seeing refunds once you as tour ops and travel agents receive your payments. What we're seeing now on the litigation front, so what's keeping us busy back at our office, is we're seeing lots of people using the small claims track procedure to seek cash refunds, because it's a very cheap way of issuing legal proceedings. You just pay the issue fee for about £150 to £250, and people can litigate themselves as litigants in person. We're seeing lots of claims for recharges under the Consumer Credit Card Act, which Ged's going to talk about later. We've seen a couple of statutory demands, so some people trying to forcefully wind up a company by saying that you're failing to meet debts that are due, by failing to make refunds. They are fully defendable unless you are in liquidation, in which case they're not. And people are also complaining that there was a failure to warn them about, before they went on the trip, that there were going to be issues in the location. Maybe their holidays were curtailed. So we're seeing some claims coming through that way. And then we've got the usual people claiming that they've caught perhaps COVID, and it's the same sort of scenario for sickness outbreaks and norovirus claims that we've seen in the past. It's people saying that they haven't got the ability to avoid COVID because they were sent to a hotel where there was COVID in the hotel. So just looking at your duty of care as a tour operator, your duty of care goes many ways, and you have quite a lot of liability. So you have to take reasonable care of all the guests who are under your control, of staff within your employment, so you can't expose them to COVID risks either, to future guests who haven't even arrived in destinations, and you have a duty to warn them. And it's not just about the warnings we're seeing here in the UK, you've got a duty to warn them of the situation that's going to be in place in the destination they're travelling to. So you have to look at what's going on locally. So we have our own government, NHS and public health service advice here in the UK, but you also need to show that you're following local advice around local hygiene and PPE equipment locally. So you need to ensure that you're providing that information to your staff and also to your guests. And then thinking about quarantine, and that's something that's changing daily. So at the end of the slides, there's a helpful websites that I've added, and there's one called Travel Pro, which is a great website. It's global, and it shows you the risks of COVID and what you should be doing in the different destinations. And it's a traffic light system, red, amber, green. So I would recommend that highly. I'm afraid there are going to be people bringing claims for COVID, as we've already heard, but also people who have been in the region or your destination and potentially had caught COVID. So they would need to show, though, that the hotel or your tour was actually the source of the coronavirus. And that's going to be pretty difficult for them to do, given that we've got quite a wide incubation period of 14 days potentially for COVID, because they would have probably been exposed to COVID potentially back here in the UK, at the airport, or wherever they went for, whatever transport hub they went through. So how can they show that the only place they've been for 2 weeks has been the hotel? So unless it's an all-inclusive, maybe Maldives hotel sort of scenario where they haven't left the hotel for 2 weeks and caught the COVID within that incubation period, or potentially a cruise ship, it's going to be very difficult for them to prove that you were the source of the COVID. Also, we're not going to have many tests here in the UK. Well, I don't know if it's better in the US. I think Trump's saying he's doing lots of testing, but in the UK, it's still quite difficult to get tests. So how do people even prove they've had COVID? So they would need to show that they had COVID with a proper test and diagnosis. And even if they have got COVID and they were in situ for 2 weeks on one of your tours, how can they show that their illness was caused by your breach of duty? You know, in what way were you negligent? Why did, you know, if you're showing that you're following all steps locally and all hygiene requirements locally and what we've been advised to do in the UK, you haven't been negligent. So again, it's going to be quite difficult for them to get home on liability, we think, at the moment. And then if we're looking at what damages are going to be paid, who knows? Because we don't really know at the moment enough about the symptoms and how long they're likely to last and the prognosis, because people are obviously talking about loss of taste and smell and the like.
Okay, just a quick question about that. Is that a similar kind of risk for just day tour operators only? Would that, do you think that risk of liability would be much reduced because of the limited time?
Yeah, if you're only with your day, absolutely. I think it would be pretty near on impossible unless you had everyone on the coach, or unless everyone on the trip went down with COVID, or a very substantial number. It'd be pretty difficult for them to show that of all the other potential sources of infection, it was that one day. So the shorter your trips, the better in some respects. If we are looking to try and defend you if someone has got COVID, we'll be asking for quite a lot of information from you, which would be, you know, where has everyone been? Where have they been visiting? What excursions did they go on? What local attractions did they go to? But we were taking that for the whole incubation period, not just for the time on your tour. And that would be both at home and overseas. Again, and from what you're saying, just then, Adam, you know, were other people on your tour reporting similar symptoms? If that's the case, then it's potentially problematic in that it may have been the tour that was the cause of the COVID, or what spread the COVID. But if actually no one else is complaining of symptoms, it's going to be much more unlikely. And if you can show that you've been following local or government advice, then again, it's going to be much more helpful to you when it comes to looking at your potential defence. As I said, they need a formal diagnosis, or PATH report, as we call it here in the UK, to show they actually did have COVID. It could be the winter vomiting virus, or it could be just some other sickness outbreak that potentially has caused a problem. Or can we look at the hotel? Do we have good documents from the hotel showing that they're following all local processes around hygiene practices which are current in view of COVID prevention? We're going to have expert evidence to hopefully show that the cause was not your tour. So we'll be relying on expert evidence in that respect, microbiologists and the like. And we'll be trying to find lots of alternative sources of infection. So pointing the finger at all other places or places of work, for example, where they could have been infected. We'll be asking you for details of how many people were on your tours, because if we can show that, you know, there was only one person out of 100 who was exhibiting symptoms, then that is much more likely to show that you're not responsible for the outbreak. But sickness logs showing how many people amongst your staff and guests have been contracting COVID, you need to have very good documentation around that. So keep, I hate to call it COVID logs, but also sickness logs. So for those that were not ill, you know, give details of their symptoms so that we can then go back and check, was anyone else likely to have been displaying similar symptoms. If people have been on your tours and using the same hotel room, and then there's potentially cross-infection there, we'll be looking to see whether the rooms have been continuously occupied, or if there's been a break in the use of the rooms, which maybe shows that it wasn't the room that was responsible. But the hotels and the people you're working with accommodation should probably have very detailed knowledge from their local hygiene advisors as to this deep clean process that's needed to eradicate the virus. So if they have had any potential concerns about COVID potentially being contracted from the hotel, what steps have they taken to eradicate it, and what is their deep clean process looking like? We haven't had any COVID litigation yet, I'm delighted to say, but we do have success in dealing with similar claims. So norovirus, we had two different cruise claims, both of which one was successful and one wasn't. And it was the documents on the TUI case, the Nolan TUI case, which demonstrated that the tour operator had proper systems in place. So the motto from the Swift case is to make sure your documentation proves that you have good systems in place around hygiene and cross-infection. For Legionnaires, we successfully defended that claim using similar arguments by saying that the Legionnaire could have come from anywhere in the resort, not the hotel, and we pointed to 2 or 3 other places which had potentially got good sources of Legionnaire in them. And then we have a good defence from Wood and TUI, which is a Court of Appeal case here in the UK, which says that a claimant must really demonstrate that there was no other place that the sickness came from but the hotel. So if people have been on different excursions and they've only been with you for a day, it'd be very difficult for a claimant to get home on the basis of this case law. So,
sorry, just Claire, just a quick question. We've had a question on the chat. What if the tour guide was to contract COVID from potentially from a customer? How likely is there any recourse on that?
Your staff, you have a non-delegable duty to staff to provide a safe place and safe system of work. So you will need to show that you've done a risk assessment around all your staff. And for anyone in the UK, you have to risk assess the risk of any harm occurring to your staff under the Health and Safety at Work Act 1974. So you should all be doing risk assessments, any European and English operators anyway for all your staff. And your risk assessment now has to take on COVID. So the government have put £114 million into the Health and Safety Executive to test what employers are doing around COVID. So I think they've got 90 new inspectors who are now being paid just to ring up different companies to say, oh, can you tell us what you're doing around COVID to protect your staff? So make sure you have addressed COVID in your risk assessment. Think about PPE, both here and in resort, and what you need to do here in the UK to protect your staff, but also what you need to do in resort to protect your staff and how you advise them of that and how you police them. So you need to have a proper risk assessment in place. Your staff must be able to understand it. And you must check that they understand what they're supposed to be doing and provide the PPE. And if you are, when the HSE call you as part of their testing to check you've got good systems in place, if they're not satisfied with your response, they will come in and inspect you and you pay for the privilege of that. And if they're still not happy, they will shut you down. So a certain law firm in Bolton was shut down recently because they felt that the distancing in the office was not appropriate, that there were not good systems in place. And when we investigated what had happened there, it seemed that members of the families of those who contracted COVID had actually called the HSE hotline and complained about the company. So if lawyers get it wrong, then that's a good warning to us all, and because we're supposed to know what we're doing. But you do need to think quite carefully about what you're doing to protect your staff, because your staff will have a very easy route to bring in a claim against you for breach of duty to them.
Okay, thank you. And if you haven't got staff, but if you're the owner operator, I guess that responsibility to still do a risk assessment for your own benefit and your own safety is still incumbent on you, is it? I
don't know if it applies to sole traders, so let me just check that for you, to be quite honest. I haven't come across a sole trader. I would have thought so, but potentially you're the owner, not the employee. So the Health and Safety at Work Act only applies to your duty to look after employees and contractors. But if you're working with contractors, you would have a similar duty to them. Okay. So
cool. I think Jeff, we'll have that same question when we get around to you about the tour guide taking potential action against a customer for potentially passing them COVID. So we'll keep that one warm as well. Thanks. Okay, thanks, Claire. Carry on.
No, thank you. So just to summarise, have processes around hygiene and follow them, but document it. For those of you getting the daily updates from the FC and DO, keep a paper trail, because every time you get the update in, you need to think about your guests in resort and the destinations that are being covered, but also do you need to bring staff back? Or when do you bring staff back? Presumably you bring staff back once you've actually evacuated all your customers, because otherwise you can't bring the staff back and look after them and leave your customers high and dry. So you have to have documentation to prove what you're doing with your risk assessment is right and appropriate. So have a way of filing the different changes to FCO advice and then keeping it alongside your risk assessment, and then changing your risk assessment as the FC&DO advice changes. As we learn more about the COVID, we'll obviously be getting information from microbiologists around causation, so we will keep feeding that through. But as long as you're following the government here in the UK or in your destinations, their advice around what to do around COVID, you can't be criticised. So it's a very tedious job, I'm afraid, given the huge numbers of alterations and amendments that are going on daily. But I'm afraid that's what you need to do. You need to keep going backwards and forwards, checking the local and the UK advice. And think about your guest volumes. Where are your biggest risks? And I'm afraid, as you would always expect, lawyers are already gearing up and advertising for COVID claims. Here in the UK, quite a few domain names have been already snapped up by some of the law firms that were dealing with sickness claims over the last couple of years. So we've got covidclaims.com, holidaycovid.com, travelcovid.com. Quite a few law firms have set up beautifully named COVID hubs. So you can go there for a one-stop shop to ask about your holiday, can you sue your employer, where else can you bring a claim? So they're trying to generate claims. So I think we certainly will see litigation around it, I'm afraid. So here's my list of the helpful resources. The Travel Health Pro is the one that gives you different destinations and information for those. The UK government is at the publication for employers and businesses about COVID. So those of you who haven't started risk assessing and have employees, that's a definite need to read. NHS is a very good source of public prevention measures, as is the Public Health Matters, things you need to do, which you should be passing on to staff and customers, or at least signposting it for customers. And then we have ABTA. Their website has got a lot of information on it and day-to-day updates as things keep changing, and also some good Q&As that you might find useful when people are saying, I want to cancel my trip, what should I do? They've got some quite helpful information. And the advice they give to guests is actually, you don't have to be a member to access, so you can just Google it and find it that way. And then I'm going to pass over to Ged, if I may. Oop.
Right. Oh,
sorry, there you go.
Great. Okay. So frustration of contract is essentially an English law doctrine, and we've mentioned it here because there have been a few both customers and suppliers who have tried to rely on this. So basically, frustration of contract would rely on an unforeseen event which occurs after the contract has been entered into by the parties. It's something that's outside the control of the parties and basically makes the contract impossible or illegal to perform. If successful, a claim under frustration of contract would result in a payback of monies that have been paid to date, and also the contract ceasing as of that point. So the existence of the force majeure clause is key here, because if that clause includes reference to pandemic or epidemic and also government acts, it's less likely that a frustration claim would be able to be relied on. And it's important, therefore, that in your B2B contracts with the suppliers and your B2C contracts, there are clauses there which cover force majeure. Moving on to Section 75 of the Consumer Credit Act and chargebacks as well. So Section 75 deals with purchases on credit cards between the amounts of 100 and 30,000. Covers off faulty goods, misrepresentation or misdescription, where a company or a merchant goes into liquidation. And it's important to note here that there's a 6-year time limit for bringing those claims. And the refunds usually come from the credit card company. Chargebacks, the refunds are given not by legislation there, or not determined by legislation, but they rely on the card scheme rules. So that's quite different to Section 75. There's no claim limit, and customers generally have between 120 to 540 days to make a claim. And in the result of that, if successful, would be that the business or the merchant pays. Once the chargeback has been received, the retailer has 45 days to dispute a reverse transaction and a further 60 days to gather evidence. A few of the points to note here: checked card services contracts such as Stripe and WorldPay. Also, it's worth challenging if the customer has a disinclination to travel, and that's the reason that they're making the chargeback. And also worth noting around Visa, because in the chargeback rules of Visa, chargebacks are not valid where the government restrictions have actually cancelled the holiday. So guidance from MasterCard and Visa on their processes for chargeback is found at those two hyperlinks there. Both advocate the cardholder trying to resolve matters with yourselves directly as merchants, as operators.
Sorry. Sorry.
And Visa also directs people to their insurers, to ABTA for advice and assistance. And both of them cover off the use of credits, which is the refund credit notes, which Claire has already referenced, for unused holidays, as being something to consider, as well as deferrals to a later date or to an alternative. Just to touch upon quickly, insurance companies and the financial conduct. The FCA have actually released a statement where they say that where customers have got a valid insurance which covers the consequences of COVID, the FCA expects the insurers to actually pay out. And that has kind of been further supported by a recent FCA High Court decision regarding business interruption insurance, which also supports the suggestion that insurance companies should actually pay out as well. And then quickly on B2B contracts here, I've got a whole list of things, but I will just pick a few out of each one. But in terms of the business-to-business contracts with the suppliers, useful clauses to include, of course, the force majeure clause, which we've already mentioned, referencing government advice, referencing pandemic and epidemics, and also allowing for a suspension of obligations in the event of a force majeure, which may also include payment, as well as termination after a certain period of time of a force majeure event. In terms of payment clauses, many things you can include here which would be useful: right of set-off of payments already made, suspension of payments in the event of force majeure, repayment of any payments that you've made where the services have not been provided, also to allow for termination there as well. An obligation on the part of the supplier to obtain refunds from subcontractors, which could then be paid back to the operators, and a right to negotiate where certain triggers are in place, such as changes to capacity and volumes in terms of passengers. On termination, it's always useful there to have a termination for convenience clause, which allows you to terminate at any time without reason. And with the indemnities, to have a chain of indemnity in place there, whereby you can pass on claims down to the suppliers and the subcontractors. And then very quickly on insurances, to allow for making sure the suppliers that are in place have public liability insurance, transport insurance, and employees liability insurance where relevant and where applicable.
Good done.
Brilliant. Thank you very much, both. Really appreciate that. We are going to, Jeff, ask you to load up your slides. If you could, so Claire, if you could just stop sharing your screen, that'd be awesome. And then Jeff, you should be able to share your screen now.
All right. Hi, everybody. I'm Jeff Ment, and thank you for listening. I'm just trying to get this to the slideshow view. So I'm going to talk about the US side of this. I think that most of the things that we've heard from Claire and Ged are applicable here, but slightly different because we don't have any national directive of anything like the package travel directive. So in the United States, and this is applicable for where the customer is coming from. So this is not related to where you are, it's related to where the customer is. And so some states have seller of travel laws, and we've listed them here. The most stringently enforced one is from California. Then we have Delaware, Florida, Hawaii, Iowa, Missouri, Virginia, and Washington. And so it doesn't matter where your trip is going. It doesn't matter where you are. It simply matters where the customer is coming from. The only states out of this list that I think you should be contemplating or thinking about are California, Florida, Hawaii, Iowa, and Washington. The other ones have regulations, but they're probably not applicable to anybody listening on this call. So you should be thinking, if you have customers coming from any of those 5 states, whether or not you need to register as a seller of travel. And I will tell you, as a lawyer, the answer is probably yes. But as a person trying to balance the legal necessity to register and the reality of running small travel companies, you may decide not to. These regulations are in place to prevent travel companies from taking advantage of consumers. And so typically, you don't see much happening from the government's perspective unless they're getting complaints about you. And so I'm assuming everybody listening on the call is thinking that they would never take advantage of a consumer, so this shouldn't be a problem for you. But most of us did not anticipate a pandemic striking, where people are been obviously trying to get as much for a refund as possible. And so we have seen so many more complaints to these regulators. The state that's obviously the most likely to take action is California. So I'd like to say California is special for lots of reasons. Not all of them are great. California's seller of travel program would be, again, applicable to any of your companies, large or small, if the customer is coming from California, and if you're arranging travel or transportation with a value of more than $300, or if the trip includes air, it doesn't matter what the cost is. If it includes air or sea transportation, again, probably not applicable to anybody listening, but those are the categories that catch you. So you can be caught up in the California regulations by virtue of what your travel product is. So this is just kind of a very high level view. We're not going to spend a lot of time reading all of this because it's kind of boring legal stuff, but I do want you to know that it's out there and you do have to register. The California seller of travel regulations really want you to tell the customer what the rules are of the road. So what are the rules of the road when booking travel with a California seller of travel? And it's all about disclosure to the customer so that they know what is required. You have to identify yourself as a California seller of travel, which is this CST abbreviation. And you would obviously stick it on your website, on brochures. You would just simply put that you're a registered seller of travel. You would have to identify your name and your address and what's being paid and what the itinerary is. All of this should be like the back of your hand. This is nothing new. You have to be very careful around cancellation terms for the California seller of travel and the other states, because they're going to make refunds easier to obtain for the customer, but not necessarily giving them the refund. It's definitely a lighter standard than the European or the UK standards. So you're not going to find yourself as regulated here. You are going to have, we don't like to use the word loopholes, but you're going to have avenues to go down or holes to go through so that you won't have to make the refund under all circumstances. Extra special thing about California, if you're actually in California, so anybody on the call now who's sitting in California, you may also have to participate in the Traveler's Restitution Fund, which is another great way for you to pay the state of California more of your hard-earned money so that they can try to levy taxes against more people. There's really nothing great about it. It's a fund to protect travelers from travel companies that go out of business. What is difficult to kind of get your arms around for the seller of travel rules are the financial obligations that you have to comply, because none of them are really the same. So in California, you're told that you can either open up a separate banking account or you can have a bond. If you are a company outside of the US and you sell to people from California, but you have no US presence yourself, it's very difficult to get a bond. So you have to try to get a bank account. That also can be difficult to establish a US bank account if you're an out-of-country operator, but we have found ways to get around that. But anyways, if you are given the choice between a trust account or a bond, you just have to really decide from an accounting perspective which one you feel like doing. The trust account is kind of a misnomer. It's not really a trust account. It's a separate checking or business account from which you put all the money in from your California customers, and you can send it out to other suppliers or to companies that you're working with, but you can't take your fee or commission until the end, until the customer is ready to travel. That's different from has already traveled, but has everything they need to be able to travel. I know this is super boring. I'm trying to make it a little more upbeat, but California seller of travel refunds, they have a whole scheme of how you have to give a refund, if you have to give a refund. Customers not entitled to a refund if they have violated any of your terms and conditions. So you still get to have all of your terms and conditions about cancellation penalties, about deposits. None of that's different. But if the customer cancels and it was no fault of their own, and they want to try to get a refund, they don't automatically get a full refund if your policy doesn't allow for a full refund. So you don't have to get too worried about this. I'm trying to be cognizant of my time here, so I don't think this is that important. Okay, so life after COVID. So like Claire and Ged, I spend all day helping travel companies around the world try to figure out what to do to get travel up and running again. We're planning for the future, and ironically, we're seeing a lot of the same things that Claire and Ged are seeing. And so we're seeing ways and reasons to redo what we have always done. So our terms and conditions, you know, Claire used the example of 1992. My God, I think some of my clients, it's from the Stone Ages, their original terms and conditions. Everybody on this call needs to wake up tomorrow morning and look at your terms and conditions. There's definitely something that you need to change. And it doesn't matter if you're a large operator or a small operator or a one-person operator, you need to have a good set of terms and conditions. And for US law and for the most likely enforcement of your provisions, they should be on your website. They should be accessible, they should be conspicuous. Those are some of the words that we see in case law here so that you can enforce them. If, for example, if you're going to have a non-refundable amount of money that's being paid to you, You have to have told the customer your terms and conditions before you take a non-refundable amount of money. The easiest way and the safest way is just to put it on your website, so you can always say, it was on our website. A force majeure is really important now. It's always been two kind of a cool sounding French words that nobody knew much about, but we spend part of every day now thinking about force majeure clauses, and it's time to kind of tighten them up. US courts are going to enforce force majeure clauses, but only to the extent that they've been written in your terms and conditions. So they have to be not vague, not ambiguous. They have to be as detailed as possible. They have to plan for the worst, whatever that means, whatever is imaginable. But here's the important part to take away from this. You can put in your force majeure for a US matter. You can put in what you're going to do for the customer if there's something that triggers a force majeure event. So what are your options? You can put in that you'll give a refund. That's the most customer-friendly option. You can put in that you won't give a refund. That's the least customer-friendly option. Or you can put in that they will get back what you are able to get back from any of your suppliers. So that's the midpoint. That's the most interesting one. And that's the one that most of my clients here want to go with. They want to be able to give back the money that they get back from the supplier. Now, if you're a supplier and you're listening, you've got to be in a different position of whether or not you're going to want to agree to give back the money, or are you going to want to give back only the unearned part of the money that you have. So I know we only have a few minutes and this topic warrants an hour by itself, but you want to really focus in on, don't just copy somebody else's force majeure language. Make it fine-tuned for your business so that it works for you. So if you're giving back as a tour operator the money that a supplier gave you back, that's great. You're getting to keep your overhead, you're getting to keep your commission, you're getting to keep your margin, but you don't have to say it that way. Instead, you say it, I'm going to give back what I get back. You can also say that you're only going to extend a credit for a force majeure event. So be creative, think about it, and obviously let Claire know, Jed, or me if you have any particular questions.
Jeff, I've got a quick question about force majeure. Are you saying that from this point on, COVID will be seen as a force majeure scenario or not?
Yeah, so we definitely have always included things like epidemics and pandemic and sickness. Yes, we're still going to maintain that more bad viruses in the future would be a trigger for a force majeure event.
Okay, thanks.
Okay, so chargebacks here, a little bit different. They're terrible. Chargebacks are terrible. It has been a horrible experience of this pandemic to see what processing companies have given back to consumers. And the reason they've given them back here is not because it was fraudulent or wrongfully charged. The credit card processing companies here are saying the customer didn't get what they paid for when they thought they were going to get it. So even in cases of postponement here, companies have lost thousands of chargebacks because the credit card company has sided with the consumer. In this chargeback analysis, remember, there's really four pieces. There's the customer, there's the customer's credit card bank, there's you, the travel person, and there's your credit card processor. The only one that really has a strong voice and vote is the customer's bank. The customer's bank is by and large deciding the chargeback, and that puts us at a great disadvantage. So what should you do? You should do exactly what Ged said. Talk to the customer, try to work this out, try to make this go away so that you don't have to be trying desperately to win a chargeback. If you do have to dispute it, and here in the US, you have far less time than you just heard about the UK, so you have to work much quicker to dispute the chargeback. Here in the US, we've also seen banks change the rules on how far back can the customer go to complain. It used to be a specific time limit. Many of the banks have lightened the rules about chargebacks here. So you want to include everything you can. You want to include all of the information related to the passing on of the terms and conditions from you to the customer. You want to give them any information about the acceptance of your terms, any signatures. We have lost chargebacks for the silliest of reasons. In one example, we lost it because the person's signature was down at the bottom of the page and it wasn't close to the words about the policy. That's ridiculous, but it still happened to us. So you really want to spend the time and the effort to piece together the best chargeback dispute you can. What can you do? Well, you can stop taking credit cards. That's probably not a great idea. But one suggestion is maybe you take a credit card only for your initial deposit, and maybe you require a wire or an ACH or a check. You obviously want to have a chargeback waiver added to your terms and conditions that says you won't do a chargeback under any circumstance. And if you do a chargeback wrongfully, we can sue you for all of our damages. We've started to add that. We've actually threatened a few people and we're ready to take action against a few because they've initiated some huge chargebacks and we're just waiting to see if they win or lose. Obviously, whether you're in the UK or the US, always get signed and written authorizations for a credit card. Post-COVID, people want to know what you're doing. Have a plan. Listen, it's an invisible virus. We cannot eradicate it by ourselves. Don't overpromise. Don't make assurances to people that we can't possibly know that we can keep them. Travel companies, tour operators, whether you're doing a day trip to go to food and beverage in a certain city, to scuba diving, stick with what you know. Don't overpromise. Don't get into the medicine business. Just tell them what you're doing and tell them you're following the government recommendations on what to do. You should follow the government recommendations. But here in the US, your duty to warn is particularly relevant for things that you know that they don't know. Here in the US, you don't necessarily have to warn for something that's equally known to the customer as it is known to you. It is obviously known to all of us that there's a virus out there that can infect us, sicken us, or kill us. So you don't have to lose your minds about new waivers and new language. Stick with what you have. You've probably already got waiver language that says the word sickness. A lot of people have asked us about new waivers and better waivers and whether you need to take people's temperatures. The answer to a lot of that is no. Don't get into the medicine business. Let the customer be forewarned that travel now is different than travel before, and they should be guided appropriately by the recommendations of the government. I've told all of my clients, don't show up with a thermometer to take people's temperatures, because unless you're prepared to give them an on-the-spot refund, I don't think it's a great idea. They might have a temperature because they have a toothache. You know, my wife jokes with me all the time. Well, I don't think she's joking. She tells me to stay out of the doctor medicine business. She's a doctor and she thinks that the rest of us shouldn't pretend to think that we know everything about medicine. So make, like Claire said, PPE, make stuff available, have sanitizer, do the right thing. And on the question about tour guides, here in the US, most tour guides that are employed under independent contractor arrangements. That's again a different webinar for about an hour talking about that. Workers' compensation laws in the United States don't apply to independent contractors. They only apply to your employee. So if you're having an independent contractor, you should have a clear agreement that they're not covered under your workers' compensation, and you can include release language that they won't bring a claim against you. So here you're a little better off from what it sounded like from Claire speaking. These are just some ideas about what some of my clients are doing. They're trying to be more flexible. They're taking less money up front. They're trying to get suppliers to lighten the deadlines for payment. So they want to pay later, so they don't have to take the customer's money as soon. They're offering these layaway opportunities, and they're offering what we sort of call here non-insurance policies. So these are things not backed up by an insurance company, but it allows you to have a more generous refund program, but it's coming out of your own pocket. So it's difficult to just do it. You have to have a plan for it. Okay, this is just the same thing. I've already talked about this. In order for a person to sue you successfully, they have to show in a duty to warn case what the duty was, that the duty of care was breached, that the breached caused an injury, and something happened that should not have happened. So travel companies should assess risk associated with activities just like you've always done. This is not new information, guys. These are things that we in the travel industry have done for decades. But we always just have to now stay on top of what are we doing, or more importantly, what are our suppliers doing on our trips that we're organizing? So if you're again, let's use the food category. If you're a tour company and you're doing food trips to New York City, you have to now know what are the restaurants doing that you're taking the people to. You need to have these conversations because they're going to protect you later. Have a risk management plan. Keep notes of what you're doing. Keep notes, because later on when you need a lawyer like Claire and Ged, they're going to ask you for your notes and for your file. Keep it electronically, keep it written, but have something so that when trouble comes your way, we can help you. Okay, some clients have said, should we send a questionnaire to people? Have you been exposed? I don't really like that idea. I don't really like the idea because I don't know what we're going to do with the information when we get it back. I don't know if you've simply been exposed to a person, how long you've been exposed. So I don't feel great about asking for health information. I do feel good about saying that you are each responsible for your own health and welfare and knowing whether or not you can participate on a trip. I do feel good about everyone signing a release and waiver here in the US that protects the travel company if the guest gets sick. So you can do that. You don't have to get into the questionnaire business. I don't think this is that important. I've probably run out of time. Insurance is something that is worthy of a conversation. Business interruption insurance has been a big bust over here. People thought it might be helpful. It turned out it really wasn't helpful. You can get some other kinds of insurance. It's expensive to get event insurance, but if you're an operator and you've got a really big thing planned, talk to somebody like an insurance broker about event cancellation coverage, because that might actually cover something like a pandemic wiping out your event. Everybody generally knows about liability insurance. If you're a travel company here in the US, you should have some kind of errors and omission insurance policy. The two biggest companies in our space in the US are Aon and Berkshire Hathaway. If you need a contact name at either company, let me know. They offer the best policies for travel people. If you are a company outside of the US, like in the UK, but you're dealing with US customers, at least have a conversation with Claire about whether or not your UK cover is going to cover you for a claim made by a US person in the US. It might, or it might not, and you might need to get a supplemental policy to cover you for US claims. Okay, that usually takes about an hour, but I got it into like 20 minutes. So
thank you, Jeff. We really appreciate you skimming through that. Yvonne?
Hey, I just wanted to say that just kind of going back to a couple of Jeff's points. One about the suppliers, and just to kind of give an example, in the case of someone who may work with a food tour, or who may be a food tour company and works with restaurants for prepaid, a prepaid situation, essentially that would be your supplier on that tour. Or if you're a tour that uses vehicles, whether it's ATVs or, bicycles that you don't own or anything like that, those that would apply. Those would essentially be your suppliers for the tour. Another point is about, this is something that we would probably spend more time on, I guess, when we have our conversation in the conference and we talk about liability waivers and agreements, is the fact that for those of you who use OTAs, you would be subject to your agreement with the OTA. So essentially the customer, and feel free, attorneys, to correct me if I'm speaking out of turn, because I'm not an attorney, only in my mind. But you would be subject to your agreement with the online travel agent like Viator, Get Your Guide, and your customer, or their customer, because essentially when your customer books through an OTA, they're that OTA's customer, not yours. You may be taking them to do the activity, but their contract is with Viator or Get Your Guide or whoever that OTA may be. So you would be subject to that. So that's something that we also could maybe further explore, in our session with them at the conference. So I just wanted to touch on those 2 points.
Claire, we'll let you go and walk the dog.
So sorry.
No, it's fine. It's cool.
There's 2 of them.
That dog was pissed.
Yeah.
Little ankle biters.
The dog was saying, "Not enough webinar. What are you doing?"
I know. Sorry.
No, it's fine. Honestly, it's cool. Don't worry about it. So yeah, thank you very much. Don't forget to sign up for our conference in November if you haven't done. The link will be on the Facebook group and the email that we'll send out after this. We'll get the slides circulated, and once this recording is rendered, we'll circulate that as well. So thank you very much, everyone. Really appreciate you joining. Have a great day.